This is Mid-Atlantic Women in Agriculture's Wednesday webinar, Hiring Maryland Farm Interns and Associated Labor Laws. Our presenter today is Sarah Everhart. A special thank you to our sponsors, Mid-Atlantic Farm Credit, Delaware Department of Agriculture, and Maryland Department of Agriculture. Downloads discussed during the webinar can be accessed at our website. And since this webinar is pre-recorded, questions will not be taken live, but can be emailed directly to the presenter. Her email address is provided at the end of the presentation. Thank you for listening.
Like Shannon said, we are here to talk about hiring interns on the farm today. It's a subject that we get quite a lot of questions about at the initiative, so I thought it would be a good subject for a webinar. We do have a publication that is nearing completion on this topic as well that should be available through our website and through local extension offices. So if you want anything that I tell you today, if you'd rather have it in print, stay tuned, and that should be coming soon. Okay, just a couple brief things about the Ag Law Education Initiative. We're a partnership with the University of Maryland School of Law and the University of Maryland College Park and the University of Maryland Eastern Shore. We're also an Empower project, which means we're a collaboration between the University of Maryland Baltimore and the University of Maryland College Park. We hope that this collaborative partnership will bring the best of all of these institutions and make the best possible resources available to farmers across the state. There's a little bit more of a more thorough description of Empower. All right, resources available. These are some of the resources that are available through the Agriculture Law Education Initiative. We have a great website. We try to keep it updated, keep it current. As you can see, there's an event calendar. This is a snapshot from a couple months ago, so we have our current events on our website now, but we have a publications library. Under that tab, you'll get easy-to-read fact sheets and publications on a variety of different legal topics, and those are updated every couple months, so keep an eye on that because they do change and publications are being added all the time. Legal resources, we have different links to environmental permitting subjects and other things that we would think would be of interest to farmers. We have videos, so if you don't want to read about a legal topic, if you'd rather just click on a video and listen to us explain it to you, we've done that for a variety of things. Under our Forms tab, we have lease forms, liability waivers, a variety of different forms that you can use, customize to your operation, take to your individual attorney, and hopefully will save you some time on those subjects. Under our quarterly update page, we do a quarterly update that can be, if you join our mailing list, we can have that emailed to you, and that's another great way to just keep on track of what we're doing and events that we're doing in the future, publications that are going to be coming out. We also have a legal info line. You can go ahead and call that number, and that actually rings now directly to my cell phone. So I will be the one that answers the phone, and I can't provide you individual legal advice, but I can give you legal resource help, which means I can point you to the law, and if I can do research for you. And if I can't provide you the help you need, I can help you find an experienced attorney who's an agricultural attorney in your area that can help you. And lastly, we have our risk management blog. Our blog is a great way to keep abreast of current legal topics. We try to update it 3 to 4 times a week. It's co-sponsored with the Maryland Crop Insurance Program. So if you're somebody that looks at the internet every day and hits a few websites, it's a great thing to join, and it's just short little blurbs. So that is our blog. A disclaimer, brief disclaimer, I'm not providing anyone individual legal advice today. This is legal education. Everyone's facts and situations are a little bit different, and so if you need individual legal advice, you should consult your personal attorney. All right, let's get started. Interns. Oh, okay, Karen, I will. It's here. The info line, 410-706-7377. Interns. Many farms across Maryland use interns to lighten their overall farm workload and also to help young people gain practical farming knowledge. We're sort of in an exciting period right now where young people are interested in learning about farming practices. People that weren't necessarily raised on farms are interested in going out to farms and learning more. And that's great. However, farm employers need to be aware of how to properly compensate interns and the legal consequences of adding them to the payroll or allowing them to be a part of the operation. Some of the questions that we get most often on the subject of interns are, can interns work for free? Or could I provide them a stipend? Do they have to be paid the minimum wage? What about if I provide meals or housing to my interns? Can then they be unpaid interns or underpaid interns? When we're thinking about these questions, farmers need to carefully consider all the applicable laws. Every time we're talking about labor issues, we need to think about federal and state laws in conjunction with each other. There's also insurance issues, which I'll touch on briefly in this arena. We need to make sure that interns are carefully covered by insurance, just like any other employees. There have been some recent nationwide legal crackdowns on the compensation of interns, so this may sound like an issue where you're thinking, yeah, if I have interns out to my farm, is anybody really going to know if the interns are happy and if it's a good thing for my operation? Is this really something I actually need to worry about? I know that farmers have a lot of things on their plates they are worried about, but this is an issue that has been brought to the forefront as of late that I'll explain here in just a second, both in and outside of the farming context. And there's some very substantial penalties and consequences for not complying with these laws. Yes, Bianca, I will provide a copy of the presentation, and we can do that for you. Okay, here's an interesting case. This was just a few years ago, back in 2013. This is an example of an intern at Fox Searchlight Pictures. They were working for the summer on the set of the movie Black Swan. They performed what you would think of as typical intern tasks, menial tasks, retrieving files, delivering paychecks, organizing file cabinets, that sort of thing. And the court held that because these activities were primarily for the benefit of the employer, which was the movie studio in this situation, and not for the education and the professional development of the intern, that the intern was actually an employee, and that the intern should have been paid the minimum wage. They were covered by the Fair Labor Standards Act, which we'll talk about more in a second. And this entitled the intern to back wages, and in most of these situations the interns are entitled to back wages and the employers are then subject to penalties for not paying proper wages. So that's just a kind of an interesting non-farm example. There has been some in the farming context. I know that there has been some litigation up in Vermont on this issue where there was quite a few farm interns and there was some labor issues up there. All right, apprentices. Briefly, I wanted to mention apprentices. Sometimes folks use the terms interns and apprentices interchangeably. They aren't interchangeable terms. The Department of Labor actually has specific definitions of internships and apprenticeships. They're different things. An apprenticeship program must be created and managed in compliance with state and federal law. Apprenticeships combine on-the-job training and related technical instruction. So there has to be some on-the-job training and then some more technical or educational formal training. The Maryland Department of Labor and Licensing administers the state apprenticeship program and requires registration of apprenticeship programs. These are rarely used in the ag context, although they could be. There are specific agricultural occupations, which, such as farm equipment mechanics, farm advisors, farm workers. These are all types of apprenticeships that could be established on a farm. I contacted the Department of Labor Licensing and asked them if they deal with this and if they know of any farms that actually have apprenticeships right now, and they said this is rarely used in Maryland, but it could be. So if this sounds like something you're interested in, I would recommend you contact them. All right, let's turn to interns. So we know what an apprenticeship is, and what about an intern? Well, The Department of Labor has established 6 legal criteria to define an internship that can be compensated at less than the minimum wage. So this is basically an unpaid intern. What is an unpaid intern? In order to have an unpaid or underpaid intern, you have to meet these 6 criteria. So let's go through them, because this is actually a pretty difficult legal standard to meet. The first is that the internship, even though it includes actual operation of the facilities of the employer, is similar to training that would be given in an educational environment. That basically means the internship has to be fairly close to a sort of classroom environment. So even though it's at your operation, it should look more like school than it does work. The second criteria is that the internship experience is for the benefit of the intern. So it has to be beneficial to the intern as opposed to beneficial to the employer. The third is that the intern does not displace regular employees but works under the close supervision of existing staff. So if an intern is taking the place of an employee, if you're contemplating getting some interns this summer, maybe you've been contacted by a local college student who wants to come out and intern for you this summer and is willing to roll their sleeves up and do some hard work on the farm, and you're thinking, great, this means I can actually hire less seasonal employment, that should set a bell off in your mind that that intern is displacing a regular employee. And if an intern is displacing a regular employee, they're acting like an employee, and therefore they need to be compensated at the minimum wage and not less than that. And the last 3, the employer that provides the training derives no immediate advantage from the activities of the intern, and on occasion its operations may actually be impeded. So these interns are supposed to be sort of underfoot. They really shouldn't be helpful, fully functioning worker-like labor. They should be student-type people who are there for their own benefit and are not giving you an immediate economic advantage. The intern is not necessarily entitled to a job at the conclusion of the internship is the next one. And finally, the employer and the intern understand that the intern is not entitled to wages for the time spent in the internship. So in order to have an unpaid or underpaid intern, all 6 of those criteria must be met. Before you accept an unpaid or underpaid intern, if you're unsure about whether or not the intern meets any of those criteria, I recommend that you consult your individual attorney and or consult the Department of Labor and Licensing Regulation. Those internship criteria are very difficult to meet in a farm setting. There are some folks across the country that are trying to establish internships for farms where they sort of create an educational component that would go along with time spent out in the field. But unless you're involved in something like that, I would hesitate before I went ahead and made any compensation decisions that went prior to that. So this is just what I said. It's a difficult standard to meet in the farming context, unfortunately. All right, so let's talk about minimum wage. So if your intern doesn't meet those 6 criteria and you have to pay them minimum wage, unless another exception applies, you have to look at a couple different things for the minimum wage. The federal minimum wage is $7.25 an hour, and the Maryland minimum wage right now is $8.25 an hour, and by this July it's going to be $8.75 an hour. So you always have to go with the higher of the state and the federal. The federal sets the minimum, and the states have the authority to require more compensation. So in Maryland, excluding Prince George's and Montgomery counties who have adopted an even higher minimum wage, you're going to have to pay your interns $8.25 in June, and then starting in July, $8.75. Workers cannot waive their right to be paid the minimum wage. So that's an important thing to sort of absorb and think about. I might run counter to common sense. If you have somebody who's interested in working on your farm and you say, hey, I'm sorry, I can't afford to add somebody else to the payroll, and the worker says, no, it's no problem, I'll accept less than the minimum wage, you might think that you wouldn't end up having a legal problem at that point, but you actually would be running counter to the law, because it's not a viable defense for an agricultural employer to claim that an intern knew and accepted an unpaid or underpaid internship. Basically, workers have the right to be paid the minimum wage. They have to be paid the minimum wage. And if you don't pay someone the minimum wage, even if they've accepted less than the minimum wage, you're at risk as the employer, so it's really not worth it. All right, here's an exception to the minimum wage, the 500 man-day exception. The 500 man-day exception allows smaller scale farming operations to pay interns and other employees, for that matter, less than the minimum wage if, during each quarter of the preceding calendar year, the farm employer used no more than 500 agricultural worker days. So in order to pay folks less than the minimum wage for this year, you have to look at each quarter of last year and see if you meet this exception. A man day is defined as any day during which an employee performs agricultural work for at least 1 hour. And there's the little calculation to show you basically how you figure it out. 7 workers at 5 days a week times 13 weeks, the amount of weeks in a quarter, you get 455 man days. Some folks hear this and they think, oh, great, this is my golden ticket out of paying minimum wage. I definitely meet that. But you have to make sure you do a thorough examination of this rule, because it's not quite, it can be kind of complex in the application. The work done by the farm employees must meet the definition of agricultural work outlined in the law. So primary agricultural work is defined in the law as planting, maintaining, and harvesting crops, as well as raising animals. Secondary agricultural work includes preparation for market, delivery to storage, delivery to market, or delivery to carriers for transportation to market. So that's sort of the umbrella of agricultural work that's covered under the 500 man day exception. It gets sticky when an employee in the same work week performs work that is exempt, which means it fits the definition of agricultural work, and work that is non-exempt. An example of this would be, let's say you have some interns out on your farm, and they're, for 80% of the week they're doing typical planting, harvesting type work. But let's say you've done all the harvesting you can do for the week, and you need somebody to paint the side of the farmhouse. It's not really related to farming. If they're painting your house, that is unrelated to primary or secondary agricultural work. They're still your worker, they're on your property, they're working for you, but that's non-exempt work. So because they're doing exempt work and non-exempt work in the same week, the employee is non-exempt for the entire week, and the minimum wage requirements of the law would apply. So that means you can't count that entire week. So, all that is to say, if you think you're close to this exception and you're planning on trying to implement it, I would keep some very careful time records of what your employees are doing, just to protect yourself. It would be just a simple log, keeping track of what your employees did every day, and if there was a week that they were doing non-exempt, non-agricultural work, you took note of that and you made sure you properly calculated it. All right, there's some other exemptions to the minimum wage. Agricultural employees who are immediate family members of your employer. So if you have someone in your family who wants to intern for you, you don't have to pay them the minimum wage. They have to be immediate members of your family. So if you have a second cousin twice removed, that doesn't count. And there's also a few more exceptions. Those principally engaged on the range and the production of livestock. Local hand harvest laborers who commute daily from their permanent residence are paid on a piece rate basis and traditionally piece rate occupations, and were engaged in agriculture less than 13 weeks during the preceding year. Minors 17 years of age or under who are hand harvesters paid on a piece rate basis and traditionally piece rate occupations, employed on the same farm as their parent and paid the same piece rate as those over 17. And Maryland also excludes employees engaged in canning, freezing, packing, first processing of perishable, seasonal fruits, vegetables, horticulture, commodities, poultry, or seafood. Unless these employees are excluded for another reason, they would still need to be paid minimum wage under the federal law. That's just a minimum, that's a Maryland exception. I see Bianca's question about the mother-in-law. Bianca, I will get Victoria to give me your email address, and I'll look that up and send you that answer this afternoon. I don't know if mother-in-law is included or not. I like the idea of mother-in-law as intern, but that's just, I'd like my mother-in-law to intern for me, but I will, I'll look that up for you and I'll get you an answer to that. Additionally, finally, if the employee is under 20 years of age, the state of Maryland permits an employer to pay the employee and an intern in this context for the first 6 months a wage that is equal to 85% of the state minimum wage. So if you have a 19-year-old intern, you get a little bit of a break for the first 6 months. Overtime. Overtime's another issue that we get a lot. Another question, rather, that we get a lot. In Maryland, agricultural employers must pay employee overtime for all hours over 60 hours a week. This is different than the federal standard, so people get confused about this. If you do a quick Google search about agricultural overtime, the federal Fair Labor Standards Act does not require overtime for ag employees, but states are all different on this subject, and this is the standard in Maryland. So if you're a Maryland operator, this is your rule. If you're listening to this webinar and you operate in Delaware or Virginia, another state, you could potentially be subject to a different standard on this. So you have to research your individual state standard. Okay, room and board. Another typical intern issue. Let's say you have a farmhouse on your property and you want to offer interns room and board. That's definitely something that you can do, but there's just some ways that it has to be done properly. And the question comes up, when can room and board be deducted from an intern's compensation? Well, the reasonable cost of board, lodging, or other facilities may be included as part of an employee's wage or an intern's wage if the facilities are regularly available to all similarly situated employees. The acceptance of the facilities is voluntary on the part of the employee, and the employee actually receives the benefits. So if you have some seasonal employees this summer and you're going to have a couple of interns and a couple of just other types of seasonal employees, not necessarily interns, you need to offer the room and board to all of your similarly situated employees. If the interns and the other types of employees are doing the same kind of work, then they're similarly situated, and so you need to offer the room and board to everyone. The acceptance of the room and board has to be voluntary, so you can't tell the interns, look, I'm paying you less because I'm giving you breakfast and I'm giving you lunch, and that's the way it's going to be. You would, in order to have some proof that it's a voluntary relationship, I would get it in writing. And, you know, just something very simple at the initiation of the employment or the internship relationship that, that you offered XYZ, maybe it's a meal, maybe it's lodging, and that they accepted those benefits voluntarily. And finally, you can't calculate the reasonable cost of board, lodging, or other facilities to exceed the actual cost to the employer. So you can only deduct from their wages what this is actually costing you. I had the question, you know, let's say I have a farmhouse on my farm and I'm just going to basically create sort of a rent figure in my head. I've looked around, and apartment type lodging in town is, you know, people are paying $500–600 a month, so I'm going to charge the interns that. No, that's not going to work. You're going to need to have some documentation to prove that you're deducting from their pay what this is actually costing you. So you're going to need to come up with a reasonable way to figure out how this works. Basically, they don't want you profiting off of a room and board type situation. Angela has asked me, can you only offer to interns living more than X miles away? I'm not exactly sure what you mean by that. Can you only offer to interns living, can you only offer room and board to interns living X miles away? You can offer room and board if you have proper facilities on your property to have folks stay there. I think that's something that you could generally offer to anyone. I would be careful on this point in terms of any type of employee, not just interns with minimum wage. Just keep very careful records of any of this. This is a situation where things can get a little bit gray. Okay, Angela's asking me, some interns may live close and do not need the housing. Oh, I understand. Okay. Yes, I would, because the law is written this way, I would generally offer it to all of your employees, even if some of them might not need it. I understand your question now. Let's say you had one intern that lived in town and one intern that's coming from across the country, and you only had a limited amount of housing. Unfortunately, because of the way the law is written, and it says that you have to offer these amenities to all similarly situated employees, and it really doesn't say anything in terms of, yes, these, let me finish answering the first question first. So, yes, I would say it doesn't matter if these are local interns or far away, or interns from across the country that have come to your operation for the summer, for example. I would offer these services to all similarly situated employees. Even the person, if they live in town, if you have room and board, if you have lodging on your farm, I would offer it to them too. And yes, I'm using the word employee because this does apply to any kind of employees. It doesn't just apply to interns. And I think that leads me to my next slide. Oh, this is just one more thing I had to say. This is what I've already said. Give written proof of the voluntary acceptance of the room and board. It's advisable that you keep very careful records of providing room and board to intern employees and consult with the Department of Labor and Licensing Regulation before you make income deductions. Similarly situated employees means employees of the same status. So let's say you had a farm manager, and then you had one farm manager and 4 farm laborers for the summer. The 4 farm laborers are similarly situated employees. They're all the same status. They have the same responsibilities, and they're paid similarly. Those are similarly situated employees. And then let's say you have a farm manager that you pay $10,000 more, that person is a supervisor, that sort of thing. You'd have to offer the room and board to all the similarly situated employees. If you only wanted to offer it to the laborers, that's fine, as long as you offered it to all the laborers. That doesn't mean you also had to offer it to your farm manager, who you pay $10,000 more and is a supervisor and has different responsibilities. So that's what similarly situated means. All right, many farmers are surprised to learn that interns performing, and not just interns, but interns in particular, performing seasonal agricultural work fall under the protections of the Migrant and Seasonal Worker Agricultural Protection Act. The Migrant and Seasonal Worker Agricultural Protection Act, it's to protect migrant and seasonal workers. If you have an intern on your farm for a summer or a semester, that's a seasonal worker. So they're covered under that federal law. If they're required to be away from their permanent residence while performing the seasonal agricultural work, they're actually considered migrant workers. And if they're not required to be away from their permanent residence while performing the work, then they're considered seasonal workers. The Act has 2 main exceptions, the 500-man-day exception, which we've already gone over, and the family business exception, which accepts a farm labor contractor working for a farm owned and operated by either himself or his immediate family member. If you're not exempt, what does the law do? Well, it requires an agricultural employer to provide migrant employees with written disclosures and seasonal employees with verbal disclosures prior to the initiation of employment regarding the place of employment, wages to be paid, types of work the intern will perform, period of employment, transportation, housing, and workers' compensation benefits. So basically you have to have some communications with these folks before they come work for you that lay out all the terms of the employment situation. You must also provide your employees with detailed pay stubs showing earnings and deductions, and you have to retain copies of payroll records for 3 years. You're also supposed to post your work site with a poster from the U.S. Department of Labor. That's a pretty brief overview of the requirements of a fairly dense federal law. So if you have any questions about how that law affects you, or if any other issues about how best to comply with that law, it would be a good idea to give your attorney a call and just to make sure that you're covering all your bases with that one. Workers' compensation. If you have 3 full-time employees or an annual payroll of at least $15,000 a year for full-time employees, then the farmer is subject to Maryland's workers' compensation law. The only people that are exempt from workers' compensation are really independent contractors. So those are the elements that are laid out there, 1 to 4. Those are individuals engaged in independent businesses that are free from the control and the direction of the employer. So keep this in mind in terms of interns. If you have interns on your farm for the summer, it might benefit you to have them covered by workers' compensation. If they're not covered by workers' compensation, you're going to want to give your insurance carrier a call and see how exactly they can be covered and how you would be protected from liability if for some reason they were injured on the farm. You know, unfortunately, injuries do happen, and we want to be covered for those situations. A word about workers' compensation and these the income test here that I just laid out. That $15,000 is not, it says it's annual payroll, which is the wording of the law, but there's actually a case that has interpreted that law to include meals that were provided to a farm laborer who was working on a dairy farm. He went in, the spouse of the dairy farmer provided him breakfast every morning after he milked the cows, and he ended up getting injured, and he wasn't covered under workers' compensation. The farmer ended up in court in trouble for not having him covered under workers' compensation, and the farmer said, look, I don't meet the requirement. I don't pay him $15,000 a year, and he's my only full-time employee. And the court said, you've been feeding him breakfast every day for X number of years, and the cost of those meals is actually included in his pay. So that's just sort of a cautionary tale on that one. That is how that has been interpreted. This is just what I said before. Make sure that interns are covered. The insurance coverage benefit is really to benefit the employer. So it's really to benefit, it's not to benefit the worker, it's to benefit the employer, because if the employer is injured, they're going to be provided coverage that they won't be provided if they're not covered by workers' compensation or another form of insurance. Then they're going to be coming after you personally. That's what you want to try to avoid.
Thank you for watching our archived presentation of our Wednesday webinar. If you would like to see more archived Wednesday webinars, please visit our YouTube channel, or to find a schedule of upcoming live webinars, visit our website.